Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing wills, girlfriends, and breakups. Why, you ask, are we discussing this? Well, I did a video about a week ago where I said, and I'll reiterate here, going back the last couple of years, we've had to deal with a lot of news dealing with Thai immigration. It seemed to be kind of the major topic of the day for a long time. And I was happy to talk about that because it was constantly changing. Thailand's reopened now. We've sort of put that in the rearview mirror, thank God. And here we are. So I asked folks, I said, look, what do you want me to talk about? And I got a lot of interesting correspondence coming back, including this comment, which was on that video, which basically said, wills, girlfriends, and breakups, legally speaking, potential hazards and liabilities. So basically, what is sort of the interplay between having a Thai will, a Thai significant other, and then that relationship ends, etc. So a couple of things to keep in mind. If we're talking specifically about girlfriends as opposed to spouses, that we need to set out here from the outset. So spouses are going to have different rights vis-a-vis one's estate compared to a significant other that is not legally married to a given individual. So, and what are we talking about here? Well, despite what a will even may say, there may be circumstances where a legally married spouse can contest that based upon their specific circumstances. Again, not going to get too deep into that. It's going to be circumstantially dependent, but bear in mind that it's a fundamentally different thing when you're talking about a legally recognized spouse as opposed to a girlfriend. Now, or boyfriend or whatever, just significant other. So the thing to understand is when you make a will, that's your testamentary instrument. So as long as you're alive, you can always change it. As long as you're alive and you have capacity. Now, if down the road, let's say you have a will, you wrote it, you specified a specific, in this case we'll call it a girlfriend, and then you die, well, guess what? If that will goes to court, regardless of what you would have otherwise wanted in the interim between your death and the writing and the formalization of that will, it's a pretty good chance the court's going to go ahead and say, well, this is the best we know what he wanted to do, so we're going to give it to that person. So whether or not a breakup has occurred in the meantime may not have anything to do with how that property is distributed per that will, because that will may be the only thing the court has to go by to deal with essentially the disbursement of one's estate. So something to keep in mind. Now, honestly, my answer to that is, look, if you're worried about that, maybe seriously reconsider who you write your will to, and maybe set something up where perhaps, you could set an executor in your will that would say and tell that executor, look, if everything's going good with me and so at the time of my death, I want so-and-so to have this, and I'm instructing you accordingly. That may be a way to deal with that. But again, it's all going to be driven by circumstances. And long story short, if you have any qualms about what is in one's will, really a good idea to deal with that early and often.